If you have not yet watched Part 1, it is recommended but not necessarily a requirement. The MMTLP fiasco is a highly unusual and problematic situation that has raised serious questions about the actions and inactions of both FINRA and the SEC. This detailed account, based on public records, FOIA requests and legal precedents, paints a picture of a regulatory process that appears to have been deliberately convoluted and potentially manipulated to the detriment of investors. As you watch, it's important that you do so from the perspective of someone at the SEC with the responsibility of reviewing these events, ensuring that investors were protected and that market integrity was upheld. This is the case against the Securities Exchange Commission, Part 2 of 5. There weren't many brokerages that allowed new buys in MMTLP for the entirety of the time it traded on the OTC. Investors who held MMTLP in Robinhood, Webull, and many other brokerages were never allowed to make new buys. This, combined with the many messages from brokerages like TD Ameritrade and Charles Schwab, which together accounted for approximately 40% of the next Bridge Hydrocarbons share allocation, means that the idea of needing to protect hypothetical investors who might have been able to make purchases after December 8th really didn't seem like a worthwhile measure, especially when it came at the expense of the actual investors that FINRA and the SEC had the responsibility to protect. In addition to this, when FINRA U3 halted SWKH in 2015, trading resumed the very next day. This is what was included in the subsequent UPC notice. Pursuant to Rule 11893A, FINRA has reviewed the trading in SWKH for September 16, 2015, and has determined to rule all such transactions in SWKH to be null and void in order to maintain a fair and orderly market and to protect investors and the public interest. Pursuant to 11893A, FINRA has determined that this ruling is not eligible for appeal. All firms with executions in SWKH on September 16, 2015 are required to cancel all trades. By comparison, not only did both MMTLP corporate actions that FINRA wasn't supposed to author include two ways of informing the corporate actions department of every brokerage to not allow new buys after December 8th, and not only were there multiple examples of client communications from brokerages big and small, explaining that they wouldn't allow new buys in MMTLP after December 8th, but that transactions after December 8th would be limited to closing transactions only and potentially forced liquidations. This, in addition to the fact that there were many brokerages that never allowed new buys since MMTLP began trading. All of this, and there was a final layer of protection for these hypothetical investors that FINRA chose to prioritize over the actual investors that held MMTLP, pursuant to FINRA's rule. 11893A, FINRA could have easily rendered any such trades null and void, therefore having any such executions cancelled. If you haven't caught on yet, it really appears that FINRA's main purpose was to prevent whatever was going to happen on December 9th and/or December 12th, and it had nothing to do with protecting investors from making new buys. The UPC halt notice for MMTLP mentioned that the halt would end concurrently with the deletion of the trading symbol on December 13th. Below this, FINRA included the following. See also Form S1 registration statement for Next Bridge Hydrocarbons Inc., stating that, immediately after the spin-off, all shares of Series A non-voting preferred stock of Meta shall be cancelled. Available here. And then there's a link. When you follow the link, it takes you to an early version of the S1 that was yet to include the December 14th date. So by never including the correct December 14th, after market close share cancellation date in either MMTLP corporate action, and by not including a share cancellation date on the UPC notice, and by not linking to a version of the S1 that included this information, it's obvious that it was FINRA's intention to conflate MMTLP symbol deletion and MMTLP share cancellation as both occurring effective December 13th. And when you're familiar with similar exchanged event-type corporate actions, it is common practice for a trading symbol to be deleted when a share is cancelled, but deletion occurs after share cancellation, and it's never mentioned in the corporate action. So when FINRA revised the MMTLP corporate action, shifting the focus to FINRA's role of deleting the symbol effective December 13th, and because they didn't also include the correct December 14th after market close share cancellation date, I imagine most market participants saw this as FINRA just reiterating what they already said. But this was very deceiving because FINRA also removed the December 14th pay/distribution date, meaning that the most important date in the corporate action was no longer included. FINRA made the overall effective date and time of both MMTLP corporate actions the 0 hour of December 13th. But according to Bridge Hydrocarbons and Metamaterials, the one-for-one exchange was supposed to occur on December 14th, after market close, after which all shares of MMTLP would be automatically cancelled. The time between the 0 hour of December 13th, 2022, and the stock market close on December 14th, 2022 Eastern Time is 40 hours. From midnight December 13th to midnight December 14th is 24 hours. Then from midnight December 14th to 4 p.m. market close is 16 hours. 24 hours plus 16 hours equals 40 hours. So it's bad enough when you see what FINRA did and you interpret it as 1 day earlier, but those 40 hours actually represented 2 business days. You have to ask yourself how many people at FINRA reviewed the MMTLP corporate actions, and how is it that with 2 opportunities to get it right, nobody pointed out that they were removing 2 full days that could have somehow been incorporated for something like, I don't know, settlement and clearance. Then, directly before the December 9th trading day, I'll say it again, the first day when position close-only transactions and potential forced liquidations were set to occur, FINRA then discovered this so-called issue related to settlement and clearance that FINRA themselves created. FINRA then ceased posting on social media for several weeks after the U3 halt. They stopped taking calls, and we soon learned that all FINRA employees were told to stay home an entire week, unless it was absolutely necessary. We'd later learn from a FOIA request that FINRA decided to keep everyone home due to alleged threats they received from investors that were angry about the halt. If this is true, it must be pointed out that the MMTLP community as we know it today didn't even exist yet. As a whole, we don't support threats. And at the time, the first couple of days after the halt, we still didn't even know if trading might have resumed that Monday. If there were threats made, we're glad no one followed through, but at the same time, where's the police report? Why not make an example out of this person so that it doesn't happen again? Could it be that there were no credible threats? Isn't there a specific procedure that needs to be followed for incidents like that? Wouldn't there be records showing that they followed that procedure? It would be terrible if we learned that they just said that in order to put a negative light on investors. Moving on. Next came FINRA's lackluster attempt to justify their actions in their FAQs. The first was released on March 16, 2023, but if the FAQ was mainly about the MMTLP corporate actions and the trading halt, isn't it odd that FINRA neglected to mention by name their Rules 6490 and 6440? Could it be because the same issue related to settlement and clearance that FINRA created, validating their use of Rule 6440 to U3 halt trading, was also among the criteria according to their Rule 6490 that they were supposed to check for before publishing the corporate actions? Did they think investors would look up these rules, recognize that FINRA had 2 Rule 6490 review periods, but still neglected to identify an issue that they claimed to only discover directly before the December 9th trading day? The only difference between finding this alleged issue related to settlement and clearance before the corporate action was published as opposed to after is that if FINRA discovered the issue beforehand, the procedure is to deem the submission deficient, notify the issuer, and leave it up to the issuer to decide if they want to appeal. In the case of MMTLP, FINRA couldn't deem the submission deficient because an appeal would highlight FINRA's actions. Both corporate actions were deficient seemingly by design, but by allowing them to be published, it gave FINRA the ability to U3 halt trading, delete the symbol during the halt, and claim that they had to do so in order to protect investors. There's just one other portion of the initial FAQ that I want to address for now. The FAQ states, FINRA incorrectly classified MMTLP as the security of a non-SEC reporting company, and as a result, incorrectly published its threshold securities list. From October 22nd, 2021 through January 4th, 2022, and from October 17th, 2022 through December 13th, 2022. This claim is the most suspicious part. FINRA is a regulator with a primary mission to protect investors and maintain market integrity. It is responsible for overseeing OTC trading and is the very body that publishes the threshold list. To claim an incorrect classification that persisted for multiple months, while a security was a designated threshold security, suggests either a profound and sustained failure of regulatory oversight or a deliberate attempt to downplay the issue. The FAQ attempts to frame the situation as a mistake in classification rather than an actual problem which fails to deliver. However, for a security to be on the threshold list at all, regardless of its classification, it must have met the objective criteria of large and persistent FTDs for 5 consecutive settlement days. FINRA's own rules, specifically FINRA Rule 4320, apply to non-reporting companies and have similar requirements to the SEC's regulation SHO. Therefore, the FTD problem existed, and the incorrect classification is a separate issue that does not negate the underlying problem of widespread FTDs. It seems the mistake was in FINRA not applying the more stringent rules of a non-reporting company to a threshold security. In essence, the FAQ is a public admission by FINRA that a major, persistent issue with failures to deliver existed in MMTLP for months at a time, and that their own handling of the situation was flawed. This raises serious questions about why it was allowed to persist for so long. So guess what happened roughly 2 weeks after the FAQ? A community member began circulating the first granted FOIA request related to MMTLP. Oddly enough, the FOIA began to circulate on April 1st, 2023, April Fool's Day. These emails were pivotal, revealing that the SEC and FINRA were aware of a problem as far back as November 2021. In the emails, we learned that FINRA and the SEC were aware of fraud tips and complaints concerning MMTLP, and as early as December 2nd, the SEC was in contact with FINRA's OTC corporate actions team for some reason. This was 4 days before the publication of the first MMTLP corporate action. Another damaging email revealed that Sam Drady, FINRA's Senior Vice President, Market Abuse, Surveillance and Market Intelligence Market Regulation, was in contact with the SEC on December 5th, 2022, a day before the first corporate action. In their conversation, Drady makes it clear that the issues related to MMAT and MMTLP were spreading at FINRA, and that they have now reached his fraud team. The last time Drady appears to have discussed this issue was November 29th, 2021, more than a year prior, when he informed someone at the SEC that it was Patricia Casimatis, FINRA's Vice President of Market Operations, that was apparently the one to have made an inquiry about MMTLP with someone at the SEC. But in this email, Drady attempts to set up a Zoom in order to share notes concerning FINRA's and the SEC's investigations, to prevent duplicating efforts, is the way he puts it. He informed them that he was blue-sheeting both MMAT and MMTLP, looking into the issuers from a fraud/manipulation angle. This information was damning because just 2 weeks prior, FINRA gave the impression that they were being transparent in their FAQ, but they totally left out this information that we learned from the FOIA emails. Of particular interest is the fact that FINRA initiated a blue sheet investigation into both MMAT and MMTLP just 1 day before the first corporate action. But according to FINRA's Rule 6490, suspecting the issuers were involved in fraud and/or manipulation was yet another reason to deem a corporate action submission deficient. This means that there was the pending SEC case related to the reverse merger, the issues related to settlement and clearance embedded into the corporate actions, and now this. And some people that oppose the MMTLP community attempt to write off the fact that FINRA proceeded the way they did, calling FINRA's role discretionary in this regard. While this might be true, When you're aware of some of the single reasons FINRA has used to deem a corporate action submission deficient, you really scratch your head, wondering how they allowed MMTLP to proceed. Now, if you'll allow me to go on a tangent, I promise it'll be worth it. Pay close attention to the process and the timeline. In February 2018, Metatron Inc. submitted a request to FINRA to process and announce a 1-for-57 reverse stock split. FINRA's Department of Operations determined the request was deficient because Metatron had failed to file 12 required periodic reports with the SEC between 2006 and 2008. The department stated that Metatron was not current in its reporting requirements to the Securities and Exchange Commission. Metatron appealed this decision to a subcommittee of FINRA's Uniform Practice Code Committee, UPC. The UPC committee affirmed the denial in June 2018, agreeing that the denial was necessary for investor protection, public interest, and market integrity. Metatron filed an application for review with the SEC on June 28, 2018. Metatron argued that the basis for FINRA's denial was factually incorrect. They contended that they had filed a Form 15 in April 2009 to terminate their SEC registration and had since been following the alternative reporting standards of the OTC Markets Group. They claimed they were current in their reporting to their regulatory authority, which they considered to be OTC markets. The SEC's review process took longer than usual, involving requests for additional briefing from both parties on multiple occasions. The SEC, in orders dated June 7, 2019 and March 19, 2020, requested clarification on issues such as Metatron's reporting obligations stemming from prior filings and its actual compliance status with OTC markets reporting standards. On February 20, 2024, the SEC issued an opinion that remanded the case back to FINRA. The SEC found that FINRA failed to adequately explain why the denial of the specific reverse stock split request was necessary for the protection of investors, the public interest, or to maintain fair and orderly markets. While FINRA had correctly identified that Metatron was deficient due to its failure to file the past SEC reports, FINRA did not provide the required second-step analysis. The SEC emphasized that FINRA must connect the denial of the specific corporate action to the stated goals of investor protection and market integrity, rather than simply basing the denial on a general failure to comply with reporting requirements. The SEC's final opinion was issued by the Commission, which at the time included Chair Gary Gensler and Commissioners Hester Pierce and Caroline Crenshaw. The decision was not issued by a single commissioner, but by the Commission as a whole. You see, this case is the perfect example at the perfect time to illustrate multiple inconsistencies. The Metatron reverse split corporate action submission was deemed deficient by FINRA for a single reason: missing filings from a decade prior. While FINRA was correct, Metatron was deficient. This was an occasion in which they misused their discretion because they failed to identify how not proceeding with the reverse split was necessary for the protection of investors, the public interest, or to maintain fair and orderly markets. Now let's think about the timeline, specifically the SEC appeal portion. Metatron filed their appeal with the SEC on June 28, 2018. By June 7, 2019 and March 19, 2020, nearly 2 years later, the SEC was still seeking clarification on certain issues. The entire process from Metatron's initial FINRA submission to their failed UPC committee appeal took about 4 months. I think after a nearly 2-year wait, FINRA and the UPC committee probably had an idea that the SEC wasn't going to see things their way. And though it took nearly 6 years, it's fascinating to see that even the SEC would have to agree that FINRA and the UPC committee don't always get it right. Though FINRA was involved in the process earlier, it was November 2022 when FINRA was officially given the responsibility to review and process the MMTLP corporate action submission. At this time, the SEC was in year 4 out of 6 in their review of the Metatron case. I'd argue that FINRA had to be almost certain that the SEC would rule against them at that point. And so here was this spin-off getting all of this attention. The FOIA emails revealed that the SEC and FINRA knew about an issue for some time, but now more departments were starting to learn as well. On December 5th, when Sam Drady began his blue sheet investigation, what did he find? A blue sheet investigation, even if the so-called issuers were the main suspects, would have involved reconstructing the entire market for MMAT and MMTLP during a specific period. They'd need to see every buyer, every seller, and every transaction to understand the trading patterns. Limiting the request to only the issuers would be like a detective investigating a crime scene, but only collecting evidence from one corner of the room. You'd be guaranteed to miss something. Investigations must be driven by data, not preconceived notions. Even if there's a primary suspect, the manipulator might be an unknown third party, or the suspect might be working with a network of undisclosed associates. Casting a wide net ensures the data is complete and can point the investigation in the right direction, even if it's an unexpected one. Isn't that odd? Because if something convinced Drady that it was necessary to initiate a blue sheet investigation into both MMAT and MMTLP, why hasn't that investigation resulted in concrete evidence to support the SEC's investigation into the reverse merger? And then there's this new insight from Metatron concerning the requirements necessary to rationalize a corporate action deficiency determination. FINRA had to know that both the pending SEC adjudication related to the reverse merger and the newly initiated blue sheet investigation were by themselves enough to justify deeming the MMTLP submission deficient. And not only did these elements more than meet the requirements for a deficiency determination, but if appealed to the SEC, it wouldn't have been difficult to convince the SEC that stopping the process was necessary for the protection of investors, the public interest, or to maintain fair and orderly markets. But the SEC is equally, if not more, liable for allowing FINRA to continue processing the MMTLP corporate action. Sam Drady informed the SEC about his fraud/manipulation investigation a day before the first corporate action was published. Not only that, but the SEC was in contact with FINRA's OTC corporate actions team regarding the MMTLP corporate action on or before December 2nd, just 4 days before the first corporate action. Finally, the SEC has been investigating the reverse merger since at least September 2021. If the SEC didn't think their investigation was enough to deny making the spin-off S1 effective, isn't it questionable that the addition of FINRA's fraud/manipulation investigation into both of the tickers derived from the reverse merger linked to the same CEOs wasn't seen as a big enough red flag to stop the process? The justification for the halt, protecting hypothetical investors from making new buys, is weak at best. The information presented shows that brokerages responsible for a significant amount of MMTLP trading volume had already restricted new buys beyond December 8th. The existence of FINRA's own Rule 11893A, which allows for the cancellation of trades to maintain a fair and orderly market, would have been a far simpler, cleaner, and more logical way to address any potential issues. The decision to impose a U3 halt and delete the symbol rather than cancelling specific trades suggests a different motive, preventing trading altogether, perhaps to avoid a major market event that would have begun on December 9th. This is further supported by the fact that the alleged settlement and clearance issue was one that FINRA itself created through its modifications of the corporate action. But the SEC's silence is perhaps the most damning part of this entire affair. Their lack of a formal public comment for nearly 3 years is highly irregular, especially for an event that has impacted a large number of retail investors and continues to be the subject of widespread public scrutiny. The FOIA emails reveal that the SEC was aware of potential issues with MMTLP as early as November 2021 and was in direct communication with FINRA about the corporate action just days before it was published. This makes it difficult to believe they were simply passive bystanders. The SEC's own ongoing investigation into the Torchlight and Metamaterials reverse merger should have been a major red flag, yet the SEC and FINRA allowed the MMTLP corporate action to proceed. This raises the question of why they didn't use their authority to halt the process, especially given the precedent from many cases similar to Metatron, in which a single criteria for reaching a deficiency determination was sufficient. The Metatron case is a crucial piece of the puzzle. It shows that FINRA's discretion is not absolute and must be demonstrably linked to investor protection and market integrity. The SEC's own ruling in the Metatron case, though it came after the MMTLP fiasco, still shows that FINRA must provide a second-step analysis. In MMTLP, FINRA had multiple clear reasons to deem the corporate action deficient: the pending SEC investigation, the newly initiated Blue Sheet investigation, and the settlement issues created by FINRA's corporate action alterations. Yet they chose not to, which is inconsistent with their handling of Metatron, a case where FINRA was far too eager to deem the submission deficient, but failed to incorporate the required second-step analysis. The fact that the SEC was already reviewing FINRA's discretion in the Metatron case while the MMTLP event was unfolding makes the SEC's inaction even more perplexing. From the perspective of the SEC's FSIO, the department with direct oversight of FINRA, or perhaps the perspective of the next level above, this situation appears to be a systemic failure of regulation. It suggests that a single, powerful regulator, FINRA, was able to misuse its discretion, perhaps under the direction of its primary oversight body, the SEC, which would explain their decision not to intervene. The lack of transparency, withholding information that only came to light due to granted FOIA requests, the contradictory public statements from the FAQs, and the apparent disregard for established rules and precedents, all point to a deliberate and orchestrated effort to handle a complex market problem outside of standard, time-proven, transparent procedures. The continued silence from the SEC only deepens the impression that there is something they don't want to explain publicly. Don't you dare touch that dial. This is only part 2 out of 5 of The Case Against the Securities Exchange Commission.